Hello, my name is Michael Tesoro and I've prepared this presentation entitled How to Get the Green Light on Your Green Claims and to Avoid the ACCC's Green Thumbs Down. Admittedly, some bad puns there, but what I'll be seeking to do is explain the ACCC's interest in environmental, green, sustainability claims and provide some guidance to business how to avoid getting in trouble with the ACCC. So avoiding the ACCC Green Thumbs Down. And I'll be looking at a lot of the previous cases ACCC has run, the guidance it's provided, and also the international standard. And I guess what I'm seeking to do here is provide really everything you need to know about the topic, not just bits and pieces. So hopefully this will answer all your questions. And I guess that image does reflect the way I think the market used to be. There was a lot of very outrageous claims being made in the markets about environmental sustainability claims. Hopefully those types of claims aren't being made anymore, that people and businesses are showing a lot more responsibility in the claims that they make. Bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice for the last 15 years to Sarah Legal Consulting, and I help companies with competition and consumer law matters. I also do provide expert advice to a couple of legal publishers on competition and consumer law issues, including LexisNexis and CCH. Prior to that, I worked at ACCC for 15 years in a variety of roles, including direct enforcement, and while I was there, I ran quite a few environmental cases, investigations. I was quite a zealot for this particular issue, and I really liked running these cases. I thought they were very important. Now, the background to this presentation is an article which I wrote many years ago called When Greenwash Won't Wash, which first appeared in the Law Society Journal in 2008, and subsequently I was asked to present it at a couple of different occasions. Firstly at the Young Lawyers Seminar in 2009, and I was very privileged to be asked by the Environmental Defenders Office to present the paper at its 25th National Conference, which is effectively its 25th birthday party, in 2010. And then subsequently EDA published my article in their journal Impact. And obviously I've updated it significantly since then with a lot of recent developments, so it is current. Out of the presentation, I'll start with an introduction, then look at the relevant law, then discuss why it's important to focus on environmental and sustainability claims. Clearly, the fact it's an ACCC priority and has been now for 2 years. Look at some ACCC past cases, look at the guidance available from the ACCC, then look at some of the recent work by the ACCC on green claims, then spend a bit of time going through the international standard on environmental labels and declarations. And this is a really important document for any company that makes a lot of claims in this area. It's a very comprehensive document, and then finish with some commentary. Now, the relevant law is pretty straightforward. It starts with Section 18, which is a general provision that says a person must not engage in conduct that's misleading or deceptive or likely to mislead or deceive. So as you can see, it's very broad, very easy to prove. The main reason it's not just used in isolation is because there's no penalty attached to it. So the ACCC will invariably take an 18 case, but they will add on some other provisions which have the sting of a penalty. The other two provisions in 29 that would be used is 29(1)(a), which to make a false or misleading representation about the supply, possible supply of goods or services, that goods are of a particular standard, quality, value, grade, composition, style, model, or have a particular history or particular use. And the ones that would be relevant there for environmental claims, clearly particular standard, quality, value, grade, composition, and potentially particular history could all be used to attack an environmental misrepresentation. And then 29(1)(g), to make a false or misleading representation that goods have sponsorship, approval, performance characteristics, accessories, uses, and benefits. So clearly the first two, sponsorship and approval, are very relevant where a company claims they have some accreditation or they comply with some Australian standard or something along those lines. Performance characteristics, uses, or benefits can also be used to attack environmental claims. And the key of using Section 29 is there are very large penalties associated with the breach. So in November 2022, the penalties increased for a breach of this provision from $10 million, 3 times the benefit, or 10% of turnover, to $50 million, 3 times the benefit, or 30% of adjusted turnover, whichever is the highest. And very quickly, the way that the adjusted turnover thing operates is effectively if a company engages in a breach for 3 years, you look at the turnover for those 3 years, add it all together, up together, and then multiply that by 30%. So that's a very large increase in the penalties, the maximum penalties available for a breach of the Australian consumer law. And I should mention that individual penalties have also gone up from $500,000 maximum to $2.5 million. The other provision that's used by the ACCC in environmental claims is section 33, and as you can see, the main difference there is a person must not in trade or commerce engage in conduct that is liable to mislead the public. So the ACCC has to show that the representation misled the public, and the elements are the nature, manufacturing processes, characteristics, suitability for the purpose, and quantity of any goods. So the ones that are usually used in relation to environmental claims is nature, sometimes manufacturing process or characteristics, and suitability for purpose. So the ACCC will usually commence proceedings under those with those three sections together in relation to environmental claims. Now, why is it important? Well, ACCC has actually had environmental and sustainability claims as a priority for 2 years now. And when Gina made her speech at the CEDA conference back in March, she emphasised that misleading claims about environmental or sustainability credentials have an impact across the economy. Consumers, shareholders and governments want to have faith in environmental representations. They don't want to be misled by smoke and mirrors when it comes to environmental initiatives. Businesses have to tell the truth about these claims. Furthermore, if you're going to make claims like environmentally friendly, green or sustainable, you have to have the evidence to back it up. You have to have reliable scientific reports, transparent supply chain information, reputable third-party certification and other forms of evidence. And that is what the ACCC is going to be requiring companies to provide if they make environmental claims. Rod Sims the previous year also emphasised the importance of this particular priority, and he focused a bit more on competition issues. He said that greenwashing is a concern for both consumers and businesses. Consumers are unable to verify the veracity of a product's credentials. That reduces confidence in these products in the market, so that's a market distorting impact. But also businesses who are doing the right thing, who are investing to ensure they can make genuinely environmentally friendly claims, investing in manufacturing processes, are losing business to companies that aren't doing the right thing. So again, that's a market distortion, it's distorting competition, and in his view, and I think the view of Gina as well, they have a role, the ACCC, in ensuring that competition is not interfered with by these types of misrepresentations. Now, the risks of making an environmental misrepresentation are very high. Clearly, the ACCC is on the lookout for cases and it's on their priority list, so everybody should be very conscious of that. But also, it's a type of issue that you tend to get a lot of consumers complaining about. I remember when I was at the ACCC, consumers would invariably write in to complain about environmental misrepresentations that they'd seen. A bigger risk probably is environmental groups. They were always coming to the ACCC with complaints about environmental issues, and they were very sophisticated complainants. They wouldn't just come along with a complaint, a picture of an advertisement. They'd come along with all the science, the scientific sources to prove that the representation was untrue, and it'd be a very well-rounded complaint. And so it made it pretty easy for the ACCC. Obviously, you had to verify things, but it was a very sophisticated complaint. So that remains a big risk today, but looking at all the recent complaints that have gone to the ACCC, which I'll discuss later on. And the final thing is competitors. If a competitor has invested a lot of money in an environmental product or a credential, they're not going to take too kindly to a competitor making similar representations without all that justification, substantiation, and they won't hesitate to complain to the ACCC. Now, the cases I'll be looking at are in the following categories: air conditioning, a number of cases that my team took many years ago, the motor vehicle cases. In some jurisdictions, environmental representation by motor vehicle companies are totally banned, and I think that might not be a bad idea. Biodegradable, compostable cases, the flushable wipes cases, and then this category of others that doesn't really fit in any particular category. Now, the first case that was taken that I think is notable is in 2003, which was run by my team. And the background to this case was that an environmental group had come into the ACCC and told us that every air conditioning manufacturer in Australia, probably in the world, was making false representations about the gases that went into the environmental products. And we looked at all this material, an extraordinary amount of material, and seemed to us that there was an industry problem. So we had to work out the best way to try and achieve general deterrence. So we chose Sanyo to sue, mainly because it seemed to be making the most extensive and blatant misrepresentations. They were claiming that their Eco Multi-Series air conditioners had environmentally friendly HFC R4/7C added, and that they were designed for a new ozone era to keep the world green, which pretty extensive representations. They also had a lot of images on all their brochures of the sea and of trees and of nature, and that obviously enhanced the impression that consumers got from their advertising that the products were environmentally friendly. Unfortunately, R407C was a potent greenhouse gas and could not be considered environmentally friendly. And remember, we got an expert report from a person from CSIRO to back us up on that point, using somebody independent, obviously. And that was a clear misrepresentation. What was probably even more concerning is some of their units had R22 in them, which was a ozone depleting hydrochlorofluorocarbon. So we took the case and we expected that would achieve some general deterrence. Sanyo gave up immediately, and the first directions hearing was actually the proceeding at which the consent orders were signed off. Now, unfortunately, we didn't think we'd achieved any general deterrence, so we decided to take a couple more cases. So we took on Daikin, whose representations weren't as blatant, but they were clearly the market leader, and they were making representations about the environmental benefits of their products. And so we raised issues with them. They responded quite positively, agreed to cease making the representations and to carry out various remedies, including publishing corrective notices on their websites, industry magazines, and writing corrective letters to customers. And then we took one more case for good measure. We took action against Dimplex, who were making similar representations as well. So by that stage, we thought we'd achieved general deterrence in the industry. And it was interesting that I subsequently received a letter in the mail, which is a printout of an email, and it was an email between two executives from overseas of large air conditioning companies, and they were talking about the ACCC's litigation in this area and activity in this area. And the tenor of the conversation was that Australia had become this no-go zone for making environmental claims by air conditioning manufacturers about the benefits of their products, but pretty much everywhere else in the world it was business as usual. That was a bit disappointing that we only could achieve general deterrence in Australia. We didn't have a broader global impact. And I'm pretty proud of my press release title there. Dimplex chills out on environmentally friendly claims. As you can tell, I've liked making puns for a very long time. Now, going to the motor vehicle case, the first involved GMH Holden, or GMH, and in 2008, the ACCC took them to court and got orders by consent that the representations they'd made about their Saab motor vehicles were misleading. And this was the campaign that was stating every Saab is green with carbon emissions neutral across the entire Saab range. And what they claimed was they were going to plant 17 native trees for every vehicle to offset the emissions generated during the life of that motor vehicle. The problem was that 17 trees was not enough trees to offset all the emissions from a vehicle. Rather, that would only offset the carbon emissions for 1 year of the motor vehicle's operation. So it's pretty misleading representation made by a very large company. Now, they were ordered to refrain from making the representation in the future and retain its marketing staff. But the other big cost to GMH was that they had to plant an additional 12,500 trees to actually offset the emissions from the vehicles that they'd sold, the Saab vehicles they'd sold. And as you can see, it also had a very negative impact on their brand. So there was a lot of negative press about GMH making these representations. I think it's fortunate for GMH that Saab wasn't that popular a car, because if it had been more popular, they would have had to sell a lot or plant a lot more trees. The next one is the V8 supercars, and it just puzzles me why organisations like V8 supercars would seek to make environmental claims. But they had this Racing Green program where they said that they would be planting 10,000 native trees to offset the carbon emissions from the V8 Championship Series as well as all associated transport emissions of the racing teams travelling to the events. Now, the concern of the ACCC was that people would think, oh, well, 10,000 trees is going to offset these emissions in a fairly short period of time, when in reality, the offset was going to occur over many decades. And that wasn't made clear to consumers. So it's a case of making a claim which may have stacked up, but not explaining it well enough to consumers, so they end up with a misapprehension as to the way it's going to work. So they agree to implement various steps to remedy this confusion. By far the worst one was a Goodyear case, and this was in 2008 that ACCC took action against Goodyear for representations about its Eagle LS 2000 range of tyres. And Goodyear made some pretty extraordinary claims about this particular tyre range, saying that it was environmentally friendly, designed for minimal environmental impact, and that its production process resulted in reduced carbon dioxide emissions. So I guess they're pretty big claims, and so the ACCC wrote to Goodyear and said, well, explain these claims, and it turned out Goodyear had absolutely no substantiation for any of these claims. They agreed to enter 87B undertaking and admitted that these environmental benefits could not be substantiated. It apologised and offered compensation. It's quite remarkable, a big company like Goodyear making such ridiculous claims. By far the worst case was Volkswagen Dieselgate. Most people are familiar with this. All around the world, Volkswagen was discovered to have made misrepresentations about the emissions from its motor vehicles, and they were fined virtually everywhere. In 2016, the ACCC took action against Volkswagen in Australia and alleged that they made engaged in misleading deceptive conduct, false or misleading representations, and conduct liable to mislead the public. So that's the section 18, 29, and 33 breaches. Now, the ACCC alleged a few specific things that between 2011 to 2015, Volkswagen misled customers by installing and not disclosing the existence of this defeat software that was included in the vehicle. So what this would do would control the exhaust gas reticulation system, and it effectively produced lower levels of nitrous oxide emissions when the vehicle was subject to tests in a laboratory. But then it switched to a normal mode under normal on-road driving conditions. So effectively, when the vehicle is being tested, the defeat software is telling the people doing the tests that the emissions are very low, which is a false representation. That's a pretty sophisticated fraud on the consumers and on the regulators. They also alleged that Volkswagen had engaged in misleading conduct by representing that the vehicle complied with Australian and European standards and all Australian regulatory requirements, when that was not true. So there are obviously emission standards that apply in Australia and overseas, and these vehicles did not comply with those standards at all. They also made, allegedly, misrepresentations that their products were environmentally friendly, clean burning, low emission, and compliant with stringent European standards. Now, that's the problem, because in Australia, they didn't meet the Australian standards, but were sort of happy with that representation. They actually claimed that the products met these much more stringent, high European standards, which they also didn't meet. So this put them in a sort of a market-leading position, and people were buying the cars thinking they were low emission. And it all turned out to be false. It was so false that had the truth been told to the relevant Australian regulators, the vehicles would not have been permitted to be sold in Australia. They would have been illegal. So that's how extreme the fraud was on the Australian public. Now, the case had a very strange history, because the ACCC and Volkswagen agreed on a settlement amount where Volkswagen would pay $75 million pecuniary penalty, and that went to Justice Foster, who rejected the settlement. He just thought it was much too low. He decided to increase it to $125 million, which is a big increase, a $50 million increase. And obviously, interestingly, Volkswagen appealed to the full federal court. The ACCC were in a bit of a bind because they sort of agreed to 75, so they were in a funny position on the appeal. But ultimately, the full federal court upheld Foster's decision. They actually hinted that maybe 125 was a bit on the light side, and then the case special leave was sought by Volkswagen to go to the High Court. I guess if you're talking about $50 million, it's worth a tilt at the High Court, but the High Court refused special leave. So that's a very serious breach of environmental representation laws in Australia. Now, I love this quote from Justice Foster at 273, and here he's discussing the penalty that's been put to him at the first instance, and he says $75 million agreed is not sufficient to meet the overriding objective of specific deterrence. It's manifestly inadequate. He notes the particularly egregious nature of the consumer fraud perpetrated by Volkswagen, the calculated nature of the fraud. And then I love this bit where he just refers to all these facts. The fact that it was perpetrated by senior management, the fact that it involved very serious deception of the Australian government regulatory authorities, the fact that the excessive emissions of nitrogen oxide were harmful to humans and the environment, the fact that Volkswagen showed no contrition, the fact that the agreed penalty is not supported by any reasoning, especially from the ACCC, it's very bad. Like, the ACCC needs to be able to substantiate its claims in relation to penalty, particularly if it's expecting everybody else to substantiate their claims. The fact that the potential maximum penalty is at least 520 million and possibly much more. So as the case was established, there has to be some theoretical link between the maximum penalty and the penalty which is awarded, and there didn't seem to be any real link between 520 million and 75 million. The fact that Volkswagen has conducted the litigation by taking every point possible, they didn't get any credit for cooperation, and the fact that it only adopted a different stance in relation to the case when basically the stage 2 of the hearing was almost upon them. So they waited for the last moment to settle. And then, as you see at the end there, he goes, Volkswagen is more than capable of paying a much larger penalty given its size and wealth, and has, of course, done exactly that in the US and Europe. So paid very, very large penalties overseas and then come to Australia and try to pay a very low penalty. So take my hat off to Foster for his approach to this case and just the clear way he expressed his concerns about the settlement amount. Now, moving to the biodegradable case, the first one that I found was 2008, where the ACCC took action against a company called St Evans, which was selling these products, Safety's Nature Nappy, as 100% biodegradable. And the court found that the biodegradable claims were false because, unfortunately for the company, the nappies did contain some plastic components that obviously could not be broken down by the biological activity of living organisms. They weren't biodegradable. So it's unfortunate for this company. They said 100% biodegradable. If they'd said maybe 90% biodegradable, they may have gotten away with it. And this is a case of overstating your environmental claim. If you overstate it, you're going to get in trouble with ACCC. Then there was a Goody Environment and UPAC cases in 2010 where the ACCC took legal action against these companies about the Goody brand plastic bags, which they claimed were biodegradable and compostable. And they made a couple of representations that it was actually biodegradable and compostable in accordance with this relevant Australian standard, which governs these issues, and also that it could be legally supplied in South Australia, which had particular laws about plastic bags. And the court held that these products were not biodegradable and compostable, firstly because they contained this heavy metal in amounts that exceeded the maximum concentration prescribed in Australian standards. So the second they were over that maximum concentration, you could no longer claim they were biodegradable. And secondly, they did not biodegrade, disintegrate or compost in accordance with the criteria prescribed by the Australian standard. So there's two problems there. Obviously, if you're going to claim that you comply with the Australian standard, you've got to make sure you comply with it. And secondly, you've got to have some way of proving you do. So that means getting a test report from a reputable testing lab. Then there was a Woolworths case in 2018. This is a case the ACCC actually lost. The ACCC alleged that Woolworths had claimed that its products had environmental benefits, the W Select Eco Picnic products, and they claimed that Woolworths had alleged that these products would biodegrade and compost in a reasonable period of time when disposed of in domestic compost bins or conventional landfill sites. Now, Justice Mortimer heard the case and she dismissed the ACCC's allegations because she found that the allegations the ACCC made were focused on compostability being a future representation. And if it had been a future representation, it was sort of agreed that Woolworths did not have a reasonable basis for any future representations. However, she concluded that it wasn't a future representation. Rather, it was a representation which was capable of being true or false at the time it was made. So therefore, it wasn't a future representation, and therefore the ACCC lost. So as it said there, as the relevant products had the capacity to be compostable at the time they were sold, the representations were not future representations and as such were not false or misleading. The ACCC appealed that to full federal court and the full federal court upheld Mortimer's decision. And it's important law in terms of the way to approach future representations, and I think this quote really captures it. The Woolworths submission basically was that products have a current quality of being poisonous, flammable, non-toxic, washable, and that exists at the date the product is sold. It's a present state of affairs. It can be either true or false. The fact that the testing or proof of the capacity of the product is something that will happen in the future when the product is used or disposed of does not alter the nature of that representation. Rather, that is how the present representation about the feature of the product is fulfilled. So there's this sort of idea that you've got to look at the product when sold, and then later on it might biodegrade or compost, but that doesn't take away from the fact that it had those qualities when it was sold. So that was a defeat for the ACCC. And I guess Mortimer said a few things. She was critical of the ACCC submissions, trying to, I guess, focus on the future activity of the product. And again, she said that is not really relevant to the question. The question is, what is the immediate characteristic of the good, which can be true or false at the time it's sold. Then there were the flushable wipe products, and there was two bits of litigation taken against Kimberly-Clark and Pental, and then an administrative undertaking with Aldi. And in 2016, the ACCC commenced its legal proceedings, both Kimberly-Clark and Pental, alleging that flushable wipes were not flushable and that the companies that represented the products had similar characteristics to toilet paper. They would break up or disintegrate in a time frame and manner similar to toilet paper and were suitable to be flushed down the toilet. When the allegations were raised with Aldi, they immediately removed the product from sale. That was in 2017 and avoided getting sued. It's probably a sensible approach to take. Now with Pental, they decided to settle the proceedings against the ACCC in 2018, and they admitted that their White King flushable wipes actually did not have the qualities that they claimed. They were not made from specifically designed material which would disintegrate in the sewage system like toilet paper. They did not have similar characteristics to toilet paper when flushed, and they were not suitable to be flushed in the sewage system. So they admitted all those things and paid a penalty of $700,000. Kimberly-Clark, on the other hand, decided to fight the case, and they were successful. The case was heard by Justice Gleeson in 2019, and she concluded that there was insufficient evidence to show that it was actually Kleenex Cottonelle flushable wipes, as opposed to wipes and products more broadly that had contributed to the problems in the sewage system. So effectively, the ACCC was unable to prove a causation issue. They were unable to prove that the big balls of wipes that were being extracted from the sewage system were Kleenex Cottonelle flushable wipes. And I actually think it was impossible to prove that through any expert evidence. So they may have been primarily Kimberly-Clark wipes in those massive balls which are clogging up the sewage system, and the chances are they probably were, because they were the market leader in the sale of these particular products, but there was simply no way of proving that they were, and so accordingly the ACCC lost that case. Now a few other cases that just fall under a general category. One my team ran back in 2007 was Energy Australia made these claims about this clean air and green future non-accredited electricity products. So they were saying to consumers that if you sign up with them, you get 100% green electricity at no extra cost, and that for every kilowatt hour of electricity you buy, the same amount of electricity will be generated from 100% renewable sources, and that's the guarantee, or guaranteed. Now, our concern was that consumers would have understood that to mean that Energy Australia was generating new sources of renewable energy and offsetting that against other products that it was selling to consumers. But really what was happening was Energy Australia was buying credits from existing renewable energy suppliers. So as we said there, we were concerned that the consumers would understand they were supporting new sources of renewable energy rather than simply offsetting their coal-fired electricity against existing sources. Now, Energy Australia didn't admit that they'd breached the law, but they did acknowledge that consumers were pretty confused by the representations, and they agreed to a range of remedies, so clearly compensation, corrective letters to customers, and we also got a contribution of $100,000 out of them to fund an educational brochure just to explain the differences between accredited and non-accredited products. And again, pretty proud of our press release title there, another pun. Energy Australia clears air about green electricity claims, so we like that title. The next one was the Global Green Plan Limited, which was a company which effectively was selling these green switch product under the Green Power Accreditation Scheme, and it was accepting payments from customers that it was purchasing renewable energy. Now, the problem was that the company had been deregistered from this particular green power scheme in 2008, but it was continuing to accept payments from customers that as if it was a member of this particular scheme. So that was misleading, and so Global Green agreed to purchase 4,000 renewable energy certificates to make up for the shortfall when it wasn't accredited. And they didn't actually comply with that undertaking, and the ACCC had to take them to court. I guess that's clearly a thing. If you're part of a scheme and you're promoting that to consumers and you lose your accreditation, you've got to immediately let customers know that you've lost your accreditation and stop accepting money on the basis that you are accredited. Momentum Energy was in 2018, and they were hit with a number of infringement notices about falsely claiming that they offered 100% renewable energy products. And this was an extensive marketing campaign, television, print, radio, social media, and the website. And it was claimed that all its energy was generated from renewable sources. And they had this particular representation: powered by Hydro Tasmania, all our electricity is 100% renewable. The problem was that Momentum was actually buying electricity through the national electricity market. And if you're buying electricity through the NEM, you don't know where it's coming from. So you don't know whether it's coming from a renewable source or coming from a coal-fired source. So that was a representation that they couldn't substantiate. And they got a pretty light, I thought, $54,000 penalty for that. Now, the lessons I think that come from those cases is don't make green representations unless you have the scientific evidence to back up the claim. It's pretty obvious, but it's surprising how often companies don't have any evidence or sufficient evidence. So you've got to make sure you have that, particularly if you're making claims about Australian standards. You've got to have the reports from reputable labs. Be careful how you use images. And a lot of the companies that were pursued back then had used images that are associated with text to advance an environmental claim. And the ACCC is going to look very careful at those claims and will sue companies for the images as well as the text. Don't overstate the environmental benefits. And there's a temptation to oversell a particular initiative. I guess the St Evans one was an example of that, where they claimed 100% biodegradable and it wasn't that high. And not going to matter if you make an absolute claim, you're going to be held to it. Make sure your green representation is not too confusing consumers. That's the Energy Australia example, when we asked them to explain to us what it meant. There was quite a confusing answer provided to us. And then finally, I think there's also Energy Australia. Sometimes an environmental benefit will be simply too complex to translate to a short, sharp marketing message. So be aware that sometimes you want to make a claim to consumers. It's just not going to work. It's too much information will have to be provided to explain what is meant by the claim. So avoid those type of claims. Now, the ACCC in more recent time has started the enforcement of its priorities in this area with an internet sweep. So on the 4th of April 2022, the ACCC launched 2 internet sweeps. Relevantly, the first one was to identify misleading environmental and sustainability claims. And they decided to conduct these sweeps over a number of weeks and then to issue their results. And those results actually came out in March 2023. And it was pretty negative what they found. They found that of the 247 businesses' sites that they looked at, 57% were identified as having made concerning claims about environmental credentials. Now in the report, they got some pretty good diagrams explaining what they did. So this is a breakdown of the businesses they swept. As you can see, a lot of takeaway packaging companies, cosmetics, food and beverages, electronics, household goods and so on. Motor vehicles is in there as well. The key takeaways, 57% of the sites they went to raised concerns, which is probably higher than I expected. That's quite a lot of companies making claims that may not be able to be backed up. Some businesses were making vague or unclear environmental claims, not providing sufficient evidence of their claims, setting environmental goals without clear plans for how these will be achieved, and using third-party certification symbols in a confusing way. So focus there on confusing your consumers. The sectors with the greatest proportion of concerning environmental claims: cosmetics and personal care, textile garments and shoes, and food and beverages. So that was a little bit surprising to me. I probably expected motor vehicles and energy to be top of the pops there, but it's some other industries. So if you're in any of those industries, I'd be very careful with the environmental claims that you're making. Now, they identified 8 major problems that they found from their sweep. Firstly, vague and unqualified claims, a lack of substantiating information, use of absolute claims, so overselling, use of comparisons, and that's very dangerous, making comparisons. You really need to provide a lot of background to the basis for those comparisons. Exaggerated benefits or omitting relevant information. The use of aspirational claims with little information on how these goals will be achieved. So saying you're going to be sort of net zero by a certain time needs to be fully explained. Use of third-party certifications, and the use of images which appear to be trust marks. So the images are very important. Now, there are some resources available. The ACCC has got this document called the Green Marketing of the Australian Consumer Law, but it was issued in 2011, and it's actually, in my view, pretty out of date. And really, if this is a priority for the ACCC, they need to sit down and rewrite that document and issue it. It's got some obvious advice: be honest and truthful, detail the specific part of the product or process you're referring to. So don't just say a product's environmentally friendly. If a part of the product has been made in an environmentally friendly way, specify that. Use language which the average member of the public can understand. Explain the significance of the benefit. So making a claim that there's a particular benefit without explaining that in detail can be problematic, and obviously be able to substantiate the claim. There's also this checklist, which is quite helpful in this document. Avoid using safe, friendly, and this is a thing. There's a view that these products are very vague and fairly meaningless in terms of environmental claims. Use plain language. Link the environmental benefit to a specific part of the product or its production process. Make sure you can substantiate your claims. And I guess think about how you'd answer a query from a consumer or from an environmental group as to the environmental benefits of your product. The checklist continues. Explain how the product's characteristic is beneficial to the environment. Avoid giving the impression the product is completely environmentally benign, and arguably no product is completely environmentally benign because energy is used to manufacture that product. Also, use claims in an appropriate context or setting. So the pretty ridiculous example there, but don't claim something has never been tested on animals, is not tested on animals if it's never tested on animals in the past. Not really an environmental claim, but. Then there's another resource which I think if you're engaging on these representations on a larger level, you should buy this standard. It's the International Standard on Environmental Labels and Declarations, Self-Declared Environmental Claims, and it sets out the objects of the standard to ensure that claims are accurate, verifiable, increase the potential for market forces to stimulate environmental improvement. So that's a real competitive issue there. Prevent, minimise unwarranted claims, reduce marketplace confusion, again improving the competitive processes, facilitating international trade and increasing opportunity to make more informed choices. So that's the objects of this standard. And in clause 5, they basically say don't use particular claims because they're pretty useless. They're vague and don't mean anything. So they've targeted environmentally safe, environmentally friendly, green, nature's friend, and ozone friendly. You're going to have a lot of trouble verifying these particular claims because they're vague and don't really mean anything. So the advice there is to stay away from those representations entirely. Then 5.7 provides another checklist of what you should be looking at. And this is obviously quite detailed: accurate, substantiate, relevant. Again, ensure the claim relates specifically to the right component of the product. Don't use language to suggest they're different benefits when they're actually the same. Avoid misinterpretation. Look at the total life cycle, and that's a very important consideration. There's no point saying a product is made in an environmentally friendly way when the disposal of that product is going to create a lot of environmental detriments. Don't claim you're endorsed or certified by an independent third party when you're not. Don't claim there's environmental improvement which does not actually exist, or exaggerate claims. Avoid making claims that are literally true but are misleading. Don't make claims that only relate to environmental aspect that either exists or is likely to be realised during the life cycle of the product. That's obvious. Ensure there's explanatory statements that fully explain the environmental claim made. Ensure you have a proper basis for any comparisons made. A lot of companies should stay away from comparisons because it's just such a fraud area. You make a comparison with another product and that other product changes, you can get caught out. So I think a lot of companies just stay away from any comparative advertising, particularly in this area. Make sure that you are disclosing all issues. For example, if there's been a recent modification to the product. Don't say that products don't have particular ingredients if they never had those ingredients in them. These sound really obvious, but this is based on what does tend to happen. It's clever, but it'll get you into trouble and prove to not be so clever after all. When you make an environmental claim, just don't leave it. Make sure you're continually reassessing it and updating any information when it becomes available. Be relevant to the area where the corresponding environmental impact occurs. So that's a very important checklist. Then you make a checklist where you go through and you consider all those issues for every environmental claim made. Now, the ACCC has been doing sweeps and a lot of background research, but it hasn't actually taken any actions in the last couple of years on environmental issues. And the organisation that has been really moving very fast on this thing has been ACCC, and has actually taken a number of actions. And I think a very good summary of these various cases is an article put out in the Lawyers Weekly written by Rafina Law from Walters Kluwer, who's a friend and a colleague who I work with at CCH, and she issued this, put out this article called ASIC's First Greenwashing Court Case and 7 Other Greenwashing Cases. So I'd encourage you to track down this article and have a read, but in that article she summarises the cases that the ASIC has taken. The Tlu Energy case, where there were claims of carbon neutrality, low emissions, and they were required to pay some infringement notice, $53,000 infringement notices. Black Mountain Energy, which were some net zero carbon emission representations, and they paid infringement notices of about $40,000. Vanguard Investments, allegations of overstating their claim to not invest in particular industries, another $40,000 infringement notice. And Diversa Trustees, again, overstating claims in relation to pollution and their involvement in harmful investments. And they were subject to a infringement notice of about $13,000. Probably the big case is some litigation actually against Mercer. And this case is very interesting because The allegation involved a claim that Mercer was making that it was not making investments in particular companies involved in carbon-intensive fossil fuels or other areas such as alcohol production and gambling. So Mercer's superannuation was a superannuation fund selling a product called the 7 Sustainable Plus Investment, where they're saying they're not investing in particular companies. And what ASIC discovered was that 15 of the companies that were part of this particular investment plan were involved in extracting or selling carbon-intensive fossil fuels. And examples there were AGL, BHP, Glencore and Whitehaven Coal. There were also some other allegations that they basically were investing in companies that produced alcohol and involved in gambling. So that they're not relevant to the environmental, but I guess it's very important if you're going to be telling consumers, particularly consumers who are interested in ethical investments, that you're not getting involved in certain investments, and it turns out that you are. So I'm going to commend that article to you to get more detail on ASIC's actions. It's sort of surprising that ACCC to be, I think, lagging a bit behind ASIC in, I guess, the enforcement of this particular priority. However, there's some pretty big cases on the ACCC's plate at the moment, and I've sort of summarised the ones that I'm aware of. There are probably many more that haven't really hit the news headlines, but the first one was back in September 2022 when the EDO, who's very active in this area, particularly their principal lawyer Kirsty Ruddock, who I used to work with back at the ACCC. She worked for AGS, and obviously very keen on pursuing these environmental cases. So an allegation was put to the ACCC, a complaint was put to the ACCC about Glencore, and it was alleging that Glencore had made misleading, deceptive representations about their carbon emissions and how they were seeking to cut those emissions. And the EDO was acting on behalf of a number of Indigenous groups who were concerned about 6 misrepresentations allegedly made by Glencore about its plans to reach net zero by 2050. The next one relates to a complaint given to the ACCC in March 2023, so quite recently, by Greenpeace, alleging that Toyota has been overstating its emissions and clean transport efforts. And what was alleged there was Toyota was advertising that it was overstating its commitment to clean transport and understating the level of emissions that are being made by its vehicles. It also alleged that Toyota had made claims that it was leading the transition to clean cars, to electric cars, when in truth Toyota has been implementing various strategies to block the take-up of electric vehicles. It's a very interesting case. They're both very interesting cases, and given the size of Glencore and Toyota, could result, if substantiated and being able to be proved by the ACCC, very large penalties. 2 other more recent cases, Etihad Airways is another complaint by the EDO to the ACCC alleging that Etihad had engaged in climate greenwashing, and in this case EDO is acting on behalf of an environmental group called Flight Free Australia, and they were saying that basically Etihad was advertising during a soccer match in 2022 that flying shouldn't cost the earth and they're going to achieve net zeros by 2050. And Flight Free has alleged that Etihad will never achieve those goals, that they do not have a significant, they claim they don't have a significant environmental impact in their business, and there's no way they're going to meet those targets. And the final one involves a variety of companies, and this is again a complaint lodged by the EDO to the ACCC over ocean plastic products. So this relates to a lot of different organisations which are claiming that they're sort of diverting plastic away from the ocean. And in this case, EDO is acting on behalf of Tagaroa Blue Foundation, and they're concerned that the terms ocean plastics and ocean-bound plastics are misleading. It's a misleading greenwashing marketing tactic, as it's simply impossible to verify, and the term misleads consumers. And they draw specific reference to the fact that the term diverting away from ocean or diverting ocean-bound plastics can include plastics which are collected 50 kilometres away from the coast. So that's a lot of plastics in suburban or industrial areas which can somehow be included in meeting this particular threshold. So that sounds quite problematic, and there could be a lot of companies caught by that. I think some large companies have been immediately removing these products from the shelves because they don't want to get in trouble. I think Bunnings removed some products immediately on hearing of this complaint. So they're big cases involving very big companies, and I don't know if any of those will actually progress to legal proceedings or a settlement, but I think when the ACCC does pursue enforcement action, A, I don't think they'll be resolving with infringement notices, and B, I think they'll be getting a very large penalty out of some of these companies. Most of this conduct seems to predate the, or not actually, some of the conduct predates the increase of the penalties, but some of this conduct doesn't predate that. It occurred after November 2022, so potentially it could be subject to the new penalty regime. So that's quite a detailed discussion of environmental issues. I think I've tried to cover everything. It's been going for about an hour now, but I guess the main takeaways there is you need to be very vigilant of your environmental claims, but don't be too cautious and avoid making representations. There's a bit of work involved in establishing a claim, having substantiation, but there are significant benefits for making environmental claims. Consumers value these claims, government values these claims, actually other businesses value these claims. So the worst thing you can do is be too cautious and say we're going to stay away from environmental claims entirely because they're too risky. I think you can do it. You just need to invest and follow the checklists that I've outlined there. Probably the international standard checklist is the best one to follow, and make sure you tick all those boxes and you can make the claim. You've got to note that there's very much higher penalties for consumer law contraventions from 2023. So we're not talking about measly $10 million or 10% of turnover. We actually be looking at $50 million, 3 times the benefit, or 30% of adjusted turnover. So the penalties are going to be astronomical. So you can't get this wrong. You need to have people helping you that understand the law. Clearly, the major focus areas: sustainability, renewable energy, carbon credit offsets. So if you're making representations in those areas, you've got to be very careful, and you've got to do more work because they're more sophisticated claims, and you need to have the evidence available to back up your claims. I guess the date when I was back at the ACCC was a bit of the Wild West with environmental claims, and you can see most of the cases we took were pretty blatant and extreme. Clearly, I think that level of carelessness has gone out of the market. And you can see in the last few years, the ACCC has been taking more cutting-edge cases in relation to biodegradability, flushable wipes. I guess in the early years we won all the cases, and in recent years they've had some losses. But the ACCC will be taking difficult cutting-edge cases against large, well-resourced companies, and I think we can see some very interesting cases coming out of the ACCC probably in the next 6 to 12 months. Another thing just to really emphasize is if you're in business, you need to have a compliance program and a marketing checklist. These are just really non-negotiables for businesses of medium, large size. Even small businesses need to have something in place. Clearly, the marketing checklist is really important. You need some sort of documentary proof that when you're making a representation, you are actually considering the consumer law, the various checklists, and then you can provide that to the ACCC if you get investigated to just prove you've undertaken some due diligence to make sure your claims are legitimate. If you can't provide the ACCC, they're going to take a very negative view and seek a bigger penalty. So clearly you need to implement processes and procedures to ensure compliance, including a marketing checklist. So that's all I've had. It's been longish, about an hour long, but as I said earlier, I've tried to cover everything you need to know. There's no point getting drips and drabs of information. So hopefully that's been helpful, looking at the earlier ACCC cases, the recent ACCC activity, probably the major investigations which are on the ACCC's plate at the moment. And I think we can expect at least one of those cases to result in some litigation, and it's going to be very interesting how the ACCC goes. And it's going to be very interesting if the conduct has happened after November 2022, the size of the penalties that the ACCC seeks, and which are ultimately awarded by the court. So that's all I had. If you have any questions about this presentation, feel free to give me a call or send me an email. Bye-bye.